Can New Jersey police officers search a parked and unoccupied car with probable cause? Hey, great question. My name is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue to Gold law enforcement training. I do teach in New Jersey, and I'm a licensed New Jersey attorney. All right. So this question is obviously going to be kind of tailored for my New Jersey officers. New Jersey does not fully comply and adhere to the federal motor vehicle standard, and you're about to see this, but maybe you'll find this interesting even if you don't work in New Jersey. All right, so here's the sitch, right? My New Jersey officer says, all right, we had a call for a crime in progress involving burglary and theft. The officers arrive, and they actually catch two people in the act of the criminal activity, right? So they got their people. They had probable cause. Their car is nearby. The cops walk over to the car, they look inside the car, and they see evidence of the crime in plain view. Can the officer search the car? All right. And the officer says, my understanding is yes, based off of a case called Witt, based off of your book, my book, the New Jersey Search and Seizure Survival Guide, which the officer says, awesome, by the way. I appreciate that, right? Then this would be fine, right? But other people are saying, no, that ain't going to work. All right. So let me give you my answer. The answer is most likely this is going to be lawful to search the vehicle. So let me go to the seminal case on this issue, which is Witt, right? And I'll put this in the description below. So basically, Witt overturned a case called Pena Flores in New Jersey, which basically said if you don't have exigency, you can't, search a car, right? And traditionally, and most of the time, generally speaking, cops almost never have real exigency when they search cars. They have the keys, the person's arrested, nobody's trying to grab evidence from the police, right? They don't have exigency, right? It's just they have the car. All right. Well, in Pena Flores, they wanted exigency. So you would see cases like cops searching a parked car under Pena Flores and getting the evidence suppressed because you can't do that. There's no exigency in parked cars, right? Usually. But then you have Witt, who says, you know what? We're going to go back and kind of like to the pre-Pena Flores days. And they said here, we return to the standards set forth in Alston, which is a case from 1981, for warrantless searches and searches of automobiles based on probable cause. Listen closely. Going forward, searches on the roadway based on probable cause arising from unforeseeable and spontaneous circumstances are permissible. However, when the vehicles are towed and impounded, absent some exigency, a warrant must be secured. So that's kind of like the balance that New Jersey wants. They're saying, look, go do your job, right? If you encounter a vehicle, usually during a traffic stop, and you develop probable cause, take care of business. However, if you know you have probable cause and you are searching for that motor vehicle, and you have time to go get a warrant, right? We don't want to give you too much latitude here. We just want to give you enough to handle 99% of the situations that you're going to confront yourself with, right? That you're going to run into. That 1%, the ones where you have the probable cause, or the 1%, or maybe it's more than that, where you tow the car back to the station, guys, go get a warrant for that. So, what do we need for a search under Witt? Probable cause. It has to be spontaneous. You didn't really expect to find the car, and it was unforeseen. Like you didn't have the probable cause yet. Also, we have some additional cases that have been decided after Witt. And all three of these cases either directly or implicitly indicate that searching a parked and unoccupied car would be permissible under Witt. Here's my first case. I'll put all these cases below. State versus Serrano, right? It's a case out of 2018. Basically what happened here is a guy robbed a Walgreens. Okay? The cops caught him. The cops showed up. The guy's car is in the parking lot. Now, they ended up getting consent from the defendant's wife. But they also had probable cause. Well, the defendant's like, oh, you can't search my car, it's parked, and you didn't really get valid consent and all this other stuff. But let me just tell you what the court said here. In sum, we agree with the judge that a motion to suppress the evidence seized from the defendant's automobile and a motion to suppress the victim's out-of-court identification would have been futile. In particular, the automobile exception to the warrant requirement applied under Witt. Do you see what they just said there? Even though the officers kind of searched the car under consent, the court said even if the cops didn't get consent, they could have searched it anyway under Witt. And this was a parked and unoccupied car. And they also said that the cops got consent as well. So there's two reasons to search it. Here is another case called State versus Eustache, a case from 2020. In a footnote, they said, I'm paraphrasing a little bit, the motor vehicle exception applies to situations involving parked and unoccupied vehicles encountered by police in public parking lots or on city streets, as well as to moving vehicles stopped on the open highway. And they're referring back to a case called State versus Martin, New Jersey Supreme Court, 1981. Remember, this is pre-Peña-Flores. Here's another case, State versus Williams, 2021. The inherent mobility of motor vehicles has long been cited as one of the rationales supporting the creation of automobile exception, right? And they're referring to Witt. So the fact that the car can move is kind of the exigency, right? Even though it might not move. However, in order for the exception to apply, all that is required is probable cause that arose under unforeseeable and spontaneous circumstances. Did that occur here in the scenario with the burglars? Yes, these cops didn't know what they were getting into. They didn't have the probable cause rolling up in time to get a warrant, right? Indeed, our Supreme Court has held that where police have probable cause to believe a vehicle contains contraband or evidence of criminal activity, a warrantless search under the automobile exception is permissible even if the vehicle is parked and unoccupied. Therefore, evidence not suppressed. So, the case all so far after Witt is in support of searching that vehicle. Now, I got to tell you at the same time, I'm not ignorant of the game or the risk that we take here with the New Jersey Supreme Court. If I had a prosecutor who told me, Anthony, I get what you're saying. I get it. In fact, you may be right. But here's where I'm at on this. I just don't want to lose anything that we already have, right? I don't want to have another Supreme Court decision out in New Jersey saying, you know what? We changed our mind. We're going to make it harder for cops. If that's what the prosecutor is saying to me, I understand. I get those type of arguments, right? You don't want to overstay your welcome with the New Jersey Supreme Court. They already have a history of making things very tough on cops. But if the prosecutor is saying, Anthony, there is no support about in New Jersey under Witt of searching that unoccupied car, then I think that's inaccurate, right? Because Witt does not require that the car be stopped as a result of a traffic stop. Now, in Witt, it was a traffic stop, but they didn't make it that a requirement, that it had to only be from a traffic stop, right? Now, there's another thing before I let you go. There are some cases in New Jersey that would also uphold this under the plain view doctrine. They would say, hey, if you can see the evidence in the car, then you can grab it under the plain view doctrine. One case is State versus Reiniger. It's a case out of 2013. And it said basically, I'm paraphrasing here, but to satisfy the plain view exception to the warrant requirement, officers just need three things. The police officer must be lawfully in the viewing area, right? On the street, can be lawfully present. The officer must discover the evidence inadvertently, meaning didn't know the evidence was there in advance. That's not what's going on here. By the way, that part of it's actually been overturned in recent case law, but I digress. And three, it has to be immediately apparent to the police that the items in plain view were evidence of a crime, contraband, and so forth. And that's, in this case, that is what the court found is all that's required to enter the car under plain view. I have to let you know the court is dead wrong on that. Plain view and plain view seizure are two different things, right? If you are you know, under this logic, you could go past somebody's window in their house and see a kilo of cocaine on the kitchen table in plain view, and then just go into the house and seize it. No, you can't. That doesn't get you into the house. You have to have another constitutional authority to get into the house, to get into the car. Well, normally, if you see things in plain view, how do you get into the car? The motor vehicle exception. You guys with me on this? Not plain view. The plain view doesn't get you into the car. The plain view only gets you the probable cause. So if there's a prosecutor out there watching this and you are basing your logic, okay, you're like, Anthony, I'm not going to use Witt. I'm going to use plain view. I think you're making a mistake there. I think your better argument is to stick with the motor vehicle exception. All right? All right, I'll put these cases below. I hope this has helped. If you guys have any follow-up questions for me, put them in the chats. I try to do a good job on keeping track of those. Or you can go to bluetogold.com/show and ask me a follow-up question. Okay? All right. Stay safe, guys. I hope this video has helped you get it right every single time. Until next time, my friends, stay safe. Thank you.